Hi everyone, my name is Annalisa Goodman and I'm here with Professor Deborah Gordon to discuss her new anthology, Feminist Judgments, Rewritten Trusts and Estate Opinions from Cambridge University Press. Deborah, thank you so much for joining me today.
My pleasure.
Well, let's just get started. I wonder if you can tell me how you became involved in the Feminist Judgments series.
Sure. The Feminist Judgments series grew out of a book of feminist judgments in Canada that was presented at a applied legal storytelling conference. And a few of the attendees said, hey, we should do a US feminist judgments project, and sent out a call for participants. And those editors of the US feminist judgments project, Bridget Crawford, Linda Berger, and Kathy Stanchi, are all people I know. And so they did a call for participants, and I thought it sounded really interesting, and I volunteered. I wrote a commentary for that one. I worked with Deborah Rohde, who's an incredible legal scholar. She rewrote the opinion, and those were all United States feminist judgments. Those were all United States Supreme Court decisions, 25 decisions, 25 commentators. And it was such a success that the series editors proposed to Cambridge to do subject matter books. And Bridget Crawford, one of the series editors, who's also a trust and estates person, asked if I would participate as an editor on that book.
So part of the series, and this anthology specifically, is based on the idea of critical opinion writing. And I wonder if you could just expand a little bit on what that is and how it's used in this anthology.
Yeah, it's funny. I was just talking about the word critical yesterday with some colleagues. So I think critical opinion writing is looking at an opinion and thinking about the conclusions it reaches, and how those conclusions were reached, and whether they needed to be reached. And in fact, I think everything we do in the law is, if we're good lawyers and creative lawyers, is critical, because we think about what is it that we want to achieve, what is our goal, what is our why, whether we're representing a client in a litigation or in a transactional matter, or whether we're a judge. What is the what, like what matters, and what is the law that's out there, and how do the two intersect? And are there more than one way that it intersects, or does it have to be a certain way? And I think somebody who would take a critical approach to it would say, we want to achieve the best result for everyone. So how do we get there? And that's a little bit of the philosophy behind this critical opinion writing.
So can you expand on how the authors are rewriting a historical opinion while viewing it through a modern lens? What are the challenges of this, and what are the benefits?
It can be very challenging. So all of the authors were required to take the opinion they were rewriting and use only the sources available at that time. So some of the decisions in the US feminist judgments book were from over a century ago. So you're fixed in time with what are your precedent at that time. You can't refer to a case that happened much later. And what is the knowledge? What is the scientific knowledge? And given that, how can you look at those materials and decide this case either the same but based on different rationale, or differently?
I wonder if you could speak a little bit about how the cases, if the cases aren't tied to precedent, or if they're not like on the book, so to speak, what do these rewritings do? Or how do they inform scholarship?
Yeah, so I think for the authors, it's something very different, right? Because we are always writing about decisions and taking on the position of a judge and thinking about what binds us as a judge, what do we have and how do we use it. So that's just a really interesting creative exercise. I think that's why people really enjoyed being part of the book and the series. For the book more generally, I mean, I think we would love it to be a resource to practitioners to think about other arguments that they could make going forward on whatever areas of law. We would like it to be, we would love law professors to use the book as a juxtaposition with cases that exist and think about, to challenge their students to think more critically about how the cases could have been. I think, so I've hit law professors, judges. We would love judges to think of that. And there are judges who think in this way, and really that, that there's always been a debate about do judges just, or judges umpires who just call the plays, right? That's a famous Justice Roberts quotation. And many people, and famously Justice Cardozo has written about, we're all people, judges are people, and we come to judicial opinion writing and decision making through very unique lenses as people, and we can't divorce who we are from the decisions we're making. And this is just a actualization of how the person writing the decision, based on what they have available to them, looks at things in different ways and can reach a different result, or can take a different path to the same result.
I'm so glad you brought that up. That's actually, I was going to ask you about this quote that's in the introduction, in which you wrote, "The rewritten opinions show how a judicial decision often depends on the judge's experiences, perspectives, and reasoning processes." And so you're kind of speaking about how these rewritten opinions can expand a judge's perspective and get them beyond their personal experience and consider different views.
Absolutely. And to think, how, which I think so many judges do, but but so many don't, to think about how we can reach, we can think about the problem in these different ways.
The editing of each piece sounds very collaborative. Can you speak more about this process?
Absolutely. So one of the real attractive components of the Feminist Judgments series, all the books in the series, and of this book in particular, was how collaborative it was. So we do so much legal scholarship in these silos, and in this project from the very beginning, there was a solicitation for opinions you might consider rewriting. We had an advisory board. We invited a whole bunch of law professors to give us ideas of opinions that they would want to include. Then we did an open call for participants, and we really tried to invite as many people in as many combinations from different areas of the law too, who also are interested in trust and estates, because we cross a lot of different boundaries, family law and health law and property law, so tax law. So we assembled this really nice, diverse group of participants. And then, of course, every opinion had one or more authors with one or more commentators, and then an editor. There were 3 editors. And so we went through various iterations of the opinion, but everybody was involved in giving feedback and in the rewriting and rethinking. So, and then the last level of collaboration has been different opportunities to present about the book and at conferences. And so it's been a really wonderful, challenging to collaborate with so many different participants, but also really thought-provoking and collaboration at its very best.
All right, so in the introduction you write, "This volume seeks to challenge readers to ask what might have been, and the sequel question, what could be. These opinions and commentaries seek to disrupt the reader's identification with the law as part of the way things are, and encourage them instead to question outcomes and to imagine different ones. By encouraging readers to create imagined pasts and futures, how do you hope the reader's understanding of the law, both its history and its future, will change?"
One of the goals of feminist legal criticism and feminist scholarship in general is to question the idea of objectivity, and that and even equality, that things that seem like they have to be a certain way, if you look at them from a different perspective, you realize that may not be true. And I'm talking about things like things that are so important to trust and estates in particular. which is all about the transfer of wealth at death. If you think about valuation, how something is valued, it's just numbers, right? But if you think about valuation for a life expectancy, women live longer than men, they earn less than men. So for example, they're going to have a different relationship to Social Security benefits, or if you are trying to do a valuation of how much trust interest is worth, you think about it differently. So that's just one example, but it is in rethinking these decisions and thinking about what the world is and what is objective reality. Taking that critical approach changes how the outcome might happen, or what we say is important in getting to the outcome. Facts become really important. Who a person is becomes really important. We have a case about virtual adoption, which is adoption or equitable adoption that takes place outside of formal legal processes. And the reality is that happens in a lot of communities of color, and of communities that don't trust the law as much because maybe they haven't had experiences with the law that are as productive. And if you think about the doctrine and who it impacts, as opposed to just the doctrine as it looks on paper, then that changes how you might treat the doctrine, whether you would respect it or say it's not valid. The case that I'm thinking of is O'Neill, and the equitable adoption doctrine didn't fit in that case, and the opinion writer, who's actually one of my co-editors, said, hey, look, this is where equitable adoptions occur, in African-American families. And these are the people who you're disserving by saying that you have to satisfy contract principles, even though it's an equitable doctrine. So those are just a couple of examples of what the overarching goal is of the project and of this book in particular, is to question the way things are and think about how else you can think. And that kind of relates back to the earlier questions about what is critical thinking, what is critical opinion writing.
That's fantastic. Thank you so much, Deborah. Where and when can people find this book?
So it is available now. It's in print. It's Cambridge University Press, and hopefully it'll be out in bookstores soon, but certainly Cambridge has it on their website. Feminist Judgments series, Rewritten Opinions.
Fantastic. Thank you so much. I really appreciate you taking the time to speak with me today.
Thanks, Annalisa.